Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, if you're enjoying our legal education content, please remember to subscribe as it helps our channel grow. Today, we are doing our weekly question answer stream, where I answer your questions and try to hang out with you and try to give something back directly to you because I appreciate each and every one of you who subscribes and watches my channel. And as long as I have the ability to do it, and as long as I have some method to do it, I want to be able to do something that helps to give something back because I really appreciate you all being here. So what we normally do is we start with questions from Discord. Then we respond to questions and statements from prior comments from prior YouTube videos. And of course, we will take any questions that pop up in the stream as they may appear. So first of all, let's start with the questions that were in Discord from the following week. Corinne asked the following question. There's been a lot of misrepresentation of policy violations of big tech recently. For instance, saying specific content violates their policy by showing X, yet the content clearly does not, or Rakita's instance of receiving an email about copyright, yet the video lists spam, scam, deceptive practices. Considering Section 230's protection requires a good faith effort at removal, can instances such as these where the policy reason is given is blatantly false, citing knowledge of falsity, get past 230 protections during a civil suit? Well, as I understand it, this is the theory that Steven Crowder is potentially suing YouTube over. So I don't believe he's actually filed the lawsuit. He sent them some sort of notice of intent to file a lawsuit, which I assume has something to do with damages down the road relating to this. So he's giving notice because by giving notice and an opportunity to cure if he wins, there's some sort of statute in play that says if you give notice that you will be able to get attorney's fees or extra damages or something like that. So he has done this because presumably there's some statute in place that says by doing this, he can get some extra award at the back end. So, and also presumably to help lead to negotiations if that kind of thing will happen. So based on what he said about it publicly, my understanding of Steven Crowder's lawsuit is along these lines. It seems to be some sort of breach of contract idea that YouTube has said, we can use our service, we can use it under these conditions, we are using it under those conditions, you're saying we're in breach when we're not, you're penalizing us for breaches we don't have, so some sort of breach of contract idea. So will all that work? I don't know. Whenever we get the actual lawsuit, I'll be happy to read it and we'll be able to see what we're going with. But that seems to be the idea. So we'll see what happens. The Section 230 language is pretty broad. But then again, YouTube can always limit themselves by their own agreement. But there's probably enough catch-all clauses in their actual terms of service that will let them get past this. So we'll see how it goes. But the answer is potentially, but you have to get into the specifics of that, and it would be a really big deal. So it seems like Steven Crowder's trying to go down that road, so we'll see how that develops. Matt asked, does the federal civil rules allow for unilateral conspiracy? I know under the model penal code it does, don't know about civil though. Not saying the Jake Paul thing is one, just curious. Well, first of all, let's talk about what unilateral conspiracy is because it's a misleading name. So typically in a conspiracy, you need two or more parties in agreement. You can't have one person conspiracies, which is why the word unilateral is somewhat misleading. Because in a conspiracy, you need two or more people in agreement. A unilateral conspiracy, which the model penal code does allow for, and that's for criminal law, and about 30 plus states have adopted this, so a little bit more than half, I believe, allows for what you call unilateral conspiracy. And the idea is where the other person is not really agreeing because they're a plant, usually because it's the government. So a classic scenario would be the police officer who, the attractive female police officer who's dressed in scantily clad clothing, who says, "Hey baby, you want to have some fun," or something like that. And she's not really offering, because it's all part of a sting operation. So she's not really offering. And when you say okay and she says okay, she's not really agreeing, because it's all part of this thing. But you don't know that. So in about half the states, you can be charged with conspiracy, and half the states you can't, because half the states say, well, you need 2 or more people to have an agreement. There wasn't really an agreement. You thought there was, but there wasn't. So there's no conspiracy. And about half the states say, it's enough that you thought there was an agreement because we're talking about your guilty mind. So you thought you were entering a conspiracy with someone else, so that's enough. At least in federal criminal law, there is no unilateral conspiracy. You do actually have to have 2 or more people. So that is how that goes. And as to federal civil law, which deals with conspiracy, I don't know specifically, but I imagine it's the same, because the model penal code augmented or changed the standard rule. The standard rule before the model penal code was you did have to have 2 actual people cooperating. And the model penal code changed that. And about 30 states or so adopted it and said, one person thinking they're in a conspiracy and attempting to form the conspiracy is enough. So the default rule was you need 2 or more people. And since the federal criminal statute didn't change it, it would be, the most logical conclusion would be that you still need 2 or more people for a civil conspiracy in the federal law too, because that would have been the common law rule. So that seems like that's probably the rule now. The K9 asked, is it legal for a company like Google to make some of their services not usable in smaller competing browsers by not letting users log into their accounts? I know it is most likely, but it seems a bit anti-competitive. And seeing how there are current lawsuits like Epic versus Apple or Spotify versus Apple for all kinds of monopolistic practices, I wonder if this could be a similar case. The problem is that these small browsers are free and don't have any damages other than to reputation. Any of those would be hard to prove, in the fact none of us have money to fight Google in court or pay more than 1 hour of some lawyer's time, maybe not even that. So the question, if it's legal for Google to make some of their services not usable, there are 2 questions you have to answer. The first is Google doing this deliberately? Are they designing their services specifically to not work with other kinds of browsers? So are they doing it in a way that is too difficult to interface with, or are they doing something to actively prevent other people from accessing their servers? So they don't have to go out of their way to make it compatible. But if they're going out of their way to make it non-compatible, then you might have a thing. So the first thing is Google doing this deliberately? If they're not doing it deliberately, then you're just done. So if it's not compatible, not because Google is making it difficult because they're trying to prevent it, but it's just difficult because of various things that Google needs, as long as they're not doing it from the improper motivation, it should be fine. The other thing that you'd have to ask is, even if Google is doing it deliberately, is it necessary in some way for the service to operate properly, either from a technical standpoint or a user interface standpoint or a security standpoint or a usability? Is there some reason that the tool is better designed that way? So even if Google's doing it deliberately, is there some reason that would justify them doing it? So simply to say that the tool is not compatible with a non-Google browser doesn't give you enough information. You'd first have to ask the question, is Google going out of its way to make it non-compatible with other browsers? And even if they are they doing it for a non-permissible reason rather than a permissible reason? And that's part of what the epic Apple lawsuit is about, because part of Apple's argument is that we need the App Store to be this way because we need the security and control to maintain the quality of our products. So that's part of the argument that's going on there. So it depends on a lot of stuff that I don't know the answers to. And let's see if the bot is working properly. It is. From R.W. Bimby. Maryland gave up the land to the Fed under the pretense it would be a stateless capital district. If that wouldn't really be a pretense in this language, it would be a condition or under the understanding. But pretense is probably not the right word here. If the district ends and the land is used for a state, does that make it fraud? No, it wouldn't make it fraud, but we covered this before. It wouldn't make it fraud. It's just a condition that runs as part of the land. So if you give someone land conditionally and the condition no longer exists, the standard rule is the land automatically reverts. And you can do that. So it wouldn't be fraud. It just would be that the land would revert back. So you couldn't create something from it other than what Maryland gave it to, because the instant you did, the land would no longer be yours. It only exists as long as you're meeting the condition. So that's the standard rule there. So, and I've said that before. So it's not an issue of fraud, but it would be an issue of reverter of land rights, which is one of the reasons that land in real property, in property law, makes lawyers' heads spin, because of things like that. There are so many interesting carve-outs and complications that can happen with land, and then your mind blows up a little bit trying to deal with it all, because anything that can happen has happened somewhere, sometime. There's a case on it. So yeah. Watching You Daily says, I am here for you tonight. Well, thank you, Watching You Daily. I appreciate it. And Eledian points it out, Blackacre. That's right, Eledian. That's exactly right. That's why the word Blackacre strikes in the heart of every lawyer. Because we know that when you say Blackacre is the name of a piece of land. It's a fictional piece of land. But it's always called Blackacre because, I don't know, we thought it was funny, I guess. Maybe because it's black things happen to it or dark things happen to it. But it's a piece of land where everything goes wrong, right? And then the question is, who owns Blackacre? And then you have to untangle all that nightmare. And one of the things that might be part of the question of who owns Blackacre is this conditional grant and reverter and stuff. As you're trying to analyze all this and you're like, oh my God, why? Just so much stuff. It's, yeah. So fun times. Yeah, Blackacre for days. So that's all the questions we have for right now, but thank you. So in response to the story I posted today with the officers who pinned down a different person on the ground, Nick Bardsley said, I'm very puzzled by the way you edited and presented this case overview. It's very unclear in your video that the appeals court actually vacated the summary judgment on the excessive force claim and sent it back for jury proceedings. Deliberate indifference judgment was affirmed, to be sure, but making that the conclusion and appearing to skip over excessive force decision is a strange editorial choice. It seems to me more interesting that the ruling contains two decisions that might seem at odds with one another to a layman, and have discussion about how that can happen at law. Nick, that is an extremely fair point and extremely well taken, and I appreciate your thought in expressing the idea. So I took a look at this, and this video wound up being 22 minutes. So I couldn't say for sure, but if I had to bet, I would bet that I originally had the other part of it highlighted, and I made a judgment call on the fly to skip over that in the interest of time. Because some of my videos are very, very long, and YouTube doesn't like it when it's very, very long. And 22 minutes is already longer than YouTube really likes it to be. So I either skipped it because I thought I wanted to focus on this one issue, or I thought we were going to lengthen time. So yeah, I probably made some sort of snap decision to not highlight the other part in the interests of other things. And probably also in also in interest of my own sanity, because again, I don't know where it was in the recording order. So, you have to factor in some human factor stuff in this too. So it was a human factor thing that, I get tired, and sometimes, depending on where it is in the sequence, I get tired and I cut it off because I'm tired and I just want to move on, or 100 other things that's going on. So yeah, it was probably some sort of snap decision. And Matt says that I'm being 100% accurate, and I wasn't well. So I cut it short because human condition failed, and I was tired. So the human condition failed, and we wound up with that. So yeah, that's what happened, right? The prep I do in advance is the highlighting of the case. I don't prep in advance how I'm going to deliver the story. That's all done on the fly. The only thing I do on the case do in advance is highlighting. And then all the jokes, all this sort of commentary, all that stuff, I'm making up on the fly. So it was just a thing of how I was feeling that day or that moment. So yeah. In response to homes are a thing, gun rights are a thing, Shubzilla said, given it's a unanimous decision written by Thomas, I found it to be quite verbose. Thomas doesn't speak much, but he writes a lot. So Thomas' decisions can be long or longer than other people's. So the 2-page Thomas decision is not particularly verbose. No. Pick unrelated. I did put in the title, or I put in the description, that it was an unrelated pick. Yeah. Picture from an unrelated episode. So yeah. Someone says, okay, this was an interesting comment in response to my title. Because I said 4 officers put knee on neck of guy lying on pavement, guy dies. So the guy says, how can 4 officers put their knee on the neck? Only 1 officer did that. Okay, that writing was, I wrote that headline a couple times to try to figure out how to write it, and that was the best I got. I acknowledge the inaccuracy in the headline. But there was no way for me to write the headline to be more accurate, or at least I couldn't do it. I wasn't able to do it. So there might have been a way to do it. I couldn't figure it out. So because I wanted the title to be misleading. I was deliberately trying to be misleading in the title. I wanted to be accurate but misleading, because I want people to think I was talking about Chauvin. And the entire introduction, right? So the entire introduction, I'm describing it in a way to make people think I'm talking about Chauvin. Now, everything I said is accurate and true, but I'm deliberately presenting it in a way to make people think that I'm talking about Chauvin, so that when we have the M. Night Shyamalan twist of it's not Chauvin Floyd after all, people will be amazed and interested, right? So that's part of the design decision. So when I was writing that story, I was trying to figure out how to write it. So all 4 officers didn't put the knee on the neck. I made that clear in the audio of it, where I said there was 1 officer with 3 other helping. So I cleared it up in the body of the story, if you like. But how do you write that headline so it's short enough and snappy enough and interesting enough? So it was slightly inaccurate, but it was the best I was able to do. So I recognize only 1 officer, not all 4 had the knee on the neck. And what I wrote was literally all 4 had the knee on the neck, which was inaccurate, but it was the best I could do without it being overly cumbersome. So, yeah. I tried. It was the best I could do. This was an interesting one, between this little exchange between Hey Y'all and T Blank. So Hey Y'all, who wants to play along with my game, said suspect on drugs, check. Excited delirium, check. Handcuffs, check. Knee on neck and back, check. Positional asphyxia, check. Prone position, check. Uncivil says the case name. Me, surprise Pikachu face. Exclamation question mark. So hey, you all had the desired reaction, and then T blank over here decides to spoil the fun by saying knee on back and not neck, as even prosecution changed that statement. Positional asphyxia was never proved to have happened. Okay, first of all, it depends on what frames of reference and what frame and time periods. In respect to Floyd, there was a knee on the neck and the knee on the back, and there were different times that things were happening. So it wasn't on the neck for the entire time period, but it was on the neck for part of the time period. And there was that. As to positional asphyxia not being proven, I mean, I'd have to disagree. The jury came back with a guilty verdict. And other than positional asphyxia, what else could cause his death? Because there's nothing else that is obvious. From Chauvin, So Chauvin did something to do it because he came back guilty. So other than positional asphyxia, there was the windpipe wasn't collapsed. There was no damage to the windpipe. There was no damage to the vertebrae. There was no, there was nothing like that. So positional asphyxia is pretty much all you have left. So I think the jury pretty much concluded positional asphyxia. So it wasn't proven except for, the jury came back with a guilty verdict. And so, yeah, it kind of was. Question is, can you practice patent law with a BS in occupational health and safety? I do not believe so, no. You'd have to check the manual, but I do not believe that qualifies. Yeah, Matt says, might want to point out how facts are proven to a jury compared to charges. So yeah, a jury's job is to determine facts and then reach the end conclusion compelled by those facts. So the Floyd Chauvin jury had a whole bunch of facts, and they were asked, did Chauvin cause his death? Among other things. And the jury said, yeah, they did. So working backwards from the verdict, because we didn't ask for the, what's it called? It has an actual name for it. It's called I forget. You usually only see them in civil cases, but there's a kind of verdict form where the jury actually asks intermediate questions and they explicitly answer them, but you almost never see them in criminal cases. You just ask for the end conclusion. So you don't know what facts they concluded. You just know the conclusion. So you have to work backwards. So you're like, okay, the jury concluded proof beyond a reasonable doubt. Guilt beyond a reasonable doubt. All right, so he's guilty beyond a reasonable doubt. Chauvin caused his death. I know they did because he just told me that. That's what the guilt beyond a reasonable doubt is. Chauvin caused his death. Okay, so Chauvin caused his death. Well, how could he have done that? What facts would the jury have to believe in order for them to conclude that Chauvin caused his death? What are the possible set of facts that they have to believe to reach the conclusion? Because now, having proven beyond a reasonable doubt, right, we interpret all the facts in light of the current status quo. So when we had innocent until proven guilty, we interpreted all the facts in light of that status quo. So all the facts are interpreted in the way that would be reasonable, that would support that conclusion, if that makes any sense. So you interpret all the facts. You still interpret them reasonably. You can't interpret them unreasonably, but you interpret them. If there's a break, like it could go this way or it could go that way, right? So if not necessarily even evenly likely, because you don't even need that much, but as long as you have a reasonable path, then you interpret all the facts to favor the not guilty verdict, right? Or the innocent standard, because that's where you are. Then once you have a conviction, you flip that on its head. Now you're interpreting all the facts in light of that reality. So, because we had the innocent until proven guilty. That happened now. That's over now. So we have guilty. So now we're going to flip everything in our mind, and we're going to say, okay, so now we're going to interpret facts, not to look for the reasonable interpretation that would lead us to a not guilty verdict, but to look for the reasonable interpretation that would lead us to a guilty verdict. What reasonable conclusions would we have to draw? And that Floyd did, or Chauvin did. And the only thing that would be apparent is the positional asphyxia. And that's the most plausible things, like, because what else is there? Not much else. So Is it proven? Positional asphyxia? Pretty much, because nothing else seems plausible, given the testimony that's present. So therefore, it has been proven, because it seems like a necessary thing for the jury to have concluded to reach the conclusion they did, and they did, and it must be correct, or at least we're going to do everything possible to assume it's correct, because that's the standard we're at now. So, all that stuff. Nick said, caught up with your reply to my comment. Thanks for the reply. Appreciate you have to edit and make commentary on the fly. To be fair, your summary did tip me off more was in the case and made me look it up. Fair enough, and I'm glad you did your own research and you saw perhaps a decision I made that was perhaps the wrong decision, but good stuff. Aledian says, well, it doesn't need to be at positional asphyxia. It could be error in the strain of breathing caused by Floyd. Heart attack was the cause of death. I forget the actual technical cause of death. I believe it was heart arrest. And then there were some other intervening causes, which memory I don't quite sue. So it could have been the panic, I suppose. So because he already had a bad heart condition and he was in a state of perpetual panic and had so much adrenaline in his body that he basically induced a heart attack. I suppose that's also possible. But yeah, so fair enough. Fair point. I guess it could also be that. Gun rights are a thing? Yes. Lollipop rights are a thing too. Less so with the lollipops. The outcome would be the same if guns had been lollipops. So is this defending lollipop rights? There is no carve out in the Constitution for lollipops. We wouldn't be saying, oh, this is also implicitly a gun rights decision if they're lollipops, because lollipops don't also have a position in the Constitution. So it's a Fourth Amendment right, and also there's some Second Amendment interest here because guns. The government can ban lollipops. The Lollipop Guild may be very unhappy about this. One would assume the Lollipop Guild would be displeased. But, the U.S. government can go up to the representatives of the Lollipop Guild and tell them, not so much with the lollipops anymore. You no longer represent the Lollipop Guild. Lollipops are bad now. So, yeah. And your good ship that you have also has to be turned over to the state. Okay. That was interesting line of jokes for me. Wow. Thank you for the $5 super chat from Michael Tenian. Appreciate that. In response to the F cheer goes to the Supreme Court with a crazy ending argument. Was that rebuttal a Chewbacca defense asking for a friend? It was something like that. It was some sort of Chewbacca defense thing, all that. Yeah. Oh, this is a good one. Tori Jones says, I wonder if the wife could have consented to the search and seizing of the firearm since she's the wife and since most states are community property, if she admits the guns aren't hers and in fact belong to her husband. No, they can't. Okay, so this is really interesting law. So if you have two or more owners of a thing for consent. So if you have two or more owners of a thing, either one of them can say yes, and also either one of them can say no. Okay? And the no would be operative. So I'll give you a simple example. The police come to a house, only the wife is there. The police say, can we come search the house? The wife says yes. Great, right? Now we move to the situation where the wife and husband are there. Police come to the house. They say, can we search the house? Wife says yes. Husband says no. No wins. So either one of their permission is sufficient unless either one of them says no. So the police don't have to go out of their way looking for a no. But if they get a no, the no controls. So they had the no because the husband was there at the time, right? So now that he's no longer there, like his no doesn't stop existing because he's no longer there. They know no because they asked him 5 minutes ago. So the fact he's no longer there doesn't change the analysis, right? They don't have his consent. They know they don't have his consent. So, yeah, but good question. So even if it's community property, she can't say yes because he said no. That's the law. If he wasn't there to say yes or no, then she could say yes or no. And also, incidentally, she could change her mind. She could say no and then she could say yes, and also the other way around. She could say yes and she could say no. So she can change her mind because she's the only one there. But if this other person's there and they say no, their no is controlling. So, good question. And I know this, by the way, because I got this question wrong with Matt. So this is one where I actually learned one from Matt because I got this question wrong. I was reviewing one of his essay questions or something, and I got this wrong. I forgot. I had forgot. I thought, oh, either one says yes. That's the other one saying no. That doesn't matter. And I was wrong. And Matt corrected me. And then I was like, I don't believe you. And then we actually looked at the bar study guides. And I read the bar study guides. It's like, oh, I was wrong. Okay. So I learned something. It happens. I forgot. So there was a time once when Matt was useful. And we keep him around in the hopes that it will happen again. Your Rogue Grace is coming back around to rewatch your coverage of this for the Toddy West lawsuit. My question is, once you hit 100K, will you buy a new watch to celebrate? And if so, what brand or style? Hope you're doing awesome. Sure, for 100,000 subscribers, I'll buy a watch. What sort of brand? What should I get? Maybe I'll get like a Russian Fortis or something. That could be cool. Like a cosmonaut stopwatch. That'd be badass, maybe. So maybe a Fortis. That'd be sweet. Someone said, appreciate you, buddy. Well, that's very nice. Thank you. You get a little heart. In response to the abortion case, and this was Griswold versus Connecticut, apparently Black knew nothing about history and hadn't read the 10th Amendment. How did Black come down in Griswold? Hold on. Let's see. So he dissented in Griswold, did he? Okay. So then why did he dissent? Oh, it's easy. No, yeah, no, he came. No, yeah, you've completely misunderstood this. I think. Black's decision dissenting in Griswold makes total sense because he thinks the state should be allowed to regulate birth control. So the majority's decision was they can't regulate birth control, at least to the extent that it would allow you to ban contraceptions among married people. And so Black dissenting makes total sense. That's consistent with Black. So I think you might have misunderstood Black or something because, yeah, I think you must misunderstood this. Matthew says, get a tag Hewer. Did I get my message about the wrong title I asked for? Wrong title. Oh, yes, about the U.S. versus Georgia thing. Yes, I did. I saw that. Thank you. Thoughts on Supreme Court taking up the abortion case? I haven't read it yet. It's a 15-week ban, right? Hmm. That seems too. It's a ban on abortion after 15 weeks, right? That they reviewed. That seems like that can't stand. 20 weeks. 20 weeks is probably as far as you can go under the current law. And I'm not even sure 100% about 20 weeks. That's pushing it. But 20 weeks seems like the limit, the utter limit under the current law. So Mississippi going to 15 weeks, I'm not so sure about. So them taking it up, I don't know. We'll see how it goes, but I doubt it's going to be interesting up. Why don't I look homeless like Nick with the same camera? I don't think we actually have the same camera. We have a slightly different camera. He has an A7 III something. His camera's actually better than mine. I have a Sony Alpha 5100, which I'm plenty happy with his camera. I'm not so sure why his is so sharp and mine's less sharp. But, you know, I look homeless because don't look homeless because I take care of myself. Melanie says, are you thinking about getting a nice watch? The question was when I hit 100K. Would I get a new watch? And I was like, sure. What watch should I get? And I was like, Fortis. Maybe a Fortis chronograph. Could be cool. Or, yeah. Because my first thought was an Omega chronograph. I was like, I don't know about the Omega. I was like, how about a Fortis? Ooh, Fortis chronograph. That could be fun. Or something like that. In response to the homes are special thing, what if you live in the car? Yeah, the Supreme Court answered that long ago. A car doesn't stop becoming a car if you live in it. A car remains a car. So, a Piaget? No, not a Piaget. If I wanted something really delicate, I'd go with, what is it that there was one I was looking at one time. Bauhaus, like the original Bauhaus, German. But I'm trying to remember his name, like the creator of the Bauhaus style. His watch was really, really interesting. It's very, very delicate though, but not really, really cool for a dress watch. But yeah. Damn right, the Homa special. I agree with you, Brigadan. Absolutely. Are there any rules on scope of exigency? Sure, lots. There's lots of exigencies cases. Yes, like the process of helping someone, and then searching for stuff, seizing something. They couldn't search for stuff, but they could do stuff in plain view. So yeah, they wouldn't be able to search, and that would be true for every exigency. Well, not quite every, but they wouldn't be able to search. But you get the you get stuff that's in plain view. Oh, maybe I'm thinking about a different watch then. If Piaget is not the delicate one, I was thinking of something else. Maybe I'm confused. In response to the community caretaking thing from Topo Musical, does the concept of community caretaking literally come from an argument in another case? Yes. If it's needed for justifying some behavior with regard to vehicles, why isn't the onus on the legislature for passing a different law? What this is and what the limits are. So the case dealing with cars, Caddy, is dealing with the Fourth Amendment as it applies to cars. So the law the legislature passed in this question is the Fourth Amendment, which is a law to be sure. And so they say, well, you can do these basically inventory searches of cars. So the legislature could pass laws dealing with this, probably, but the question would be how far can they go? in which case you're under the Fourth Amendment analysis, and there you are. Would I rather drink a drink of apple juice thinking it's milk, or drink milk thinking it's apple juice? I'm not sure either one would please me. Probably milk, probably apple juice. Take a drink of apple juice thinking it's milk. That's probably slightly better. What I think of cops asking for IDs from passenger, I never really thought about, to be honest. Under the current law, there's probably no reason to require them. In response to drug sniffing dog leads to police misconduct, that pause, okay, let's just read it again. Yeah, I like it when I have those moments in my live streams where I say, we should probably read that again to make sure that we fully understand and appreciate it. Make sure we really get this so we don't go over it too fast. So you say a car will not have the protections of home, even lift in. What about an RV? Does it move? Can I become a sovereign citizen if I'm treading international waters? Actually, no. No. Because the U.S. government has jurisdiction over you everywhere. Seriously. Assuming you're a U.S. citizen, of course. Assuming you're a U.S. citizen. And this would be equally true of any citizen of any other country in the world. The place that you're a citizen of has jurisdiction over you everywhere because you're a citizen of the country. So the U.S. government, even if you're in the middle of international waters, they can get you. Even if you're in a different country, they can get you. So, for example, an example where this is true, it is illegal to go to a foreign country for the purpose of engaging in underage sex tourism. So even though it might be legal where you are, you can be arrested and charged for that, even though it occurred in a different country. You're like, that's not fair. It is legal there. It's like, yeah, it's legal there, but let's talk about our laws. And our laws forbid you to do that. This is also, incidentally, why you have to pay taxes no matter where you live in the world. So you being in you floating water in the middle of the ocean is not going to help you. The U.S. government can still get to you, man. Okay. In response to the James Charles lawsuit, Melissa Boomer of the Night says, "Oh man, I'm very sorry I missed this live. This is truly the only one of your streams that I have legal expertise in. I was called to testify in more EE-SEP and more EED cases than I can ever count as HR director of Fortune 100. In one case, a former sorority sister had to cross me as she became a partner in O'Melvin and Myers. Edit, in regards to a reasonable accommodation in California, you'd be surprised what individual employees can get with." Which I think I made a point of saying that I was only answering for the federal law because who knows how batshit crazy California is, but yeah. Just like everywhere else, it depends on how good the attorney is and who the judge is. The organization I'm referring to above still has a massive wage gap that I assisted in cover up. We openly discussed in board meetings method of interviewing to uncover disabilities if we suspected them, without having those uncovered in court. My Twitter handle now has what I do: consult and testify before a California EDD. Fight this kind of crap in California because despite their progressive leanings and my libertarian attitude, like everywhere, the wealthy elite controls everything. I want freedom, and COVID has been the great equalizer for customer service reps and sales reps who don't have driver's licenses rather than California IDs. Online job applications here still won't change that. That was a lot of really, really cool information. Thank you. Really, really nice. What about the underage drinking illegal here at 16 in Europe? I'm not aware of any specific U.S. law on the issue, but yeah, the extra. This is extraterritoriality. This is extraterritoriality. I think I said that right. Extraterritoriality. So if you're interested in this subject, you can Google extraterritoriality of United States law and look it up more. But yeah, that's what you're looking for. Actual question: you know if it's possible to get a possession of marijuana charge dropped in Michigan now that marijuana has become recreational? Don't know. It would depend on the specifics of Michigan law. What is EED? I assume it's some sort of equal opportunity thing, equal opportunity discrimination thing. That's what I read it as. Extraterritoriality. Yeah, what they said. Whatever they're typing, that word. So go type that word plus U.S. law, and you can learn some more stuff. Extraterritoriality. It's a tongue tire. In response to the prurient officer banned from social media, I wonder if anyone will attempt to use this precedent to argue that at least nonviolent felons can't be denied the right to keep and bear arms. Unless the Second Amendment is a second-class right, such a ban is overbroad and not narrowly tailored. Maybe, possibly. Equal Employment Department. There you go. Craig Innes, in response to the Jake Paul thing, says, "Your explanations and analysis are excellent. They really help the non-lawyer get an idea of what's going on. Sarcasm is excellent too. I enjoy your channel." Thank you. That's very nice. In response to the Capitol riots, big thumbs up for the song. We got some lovers of the song. I wrote it for you guys. I wrote it for you. Miss Melissa Boomer of the Night comments to say thank you. I'm sure it wasn't your cup of tea. Didn't study my new setup long enough. I still appreciate it. Yeah, so I dropped on a Melissa Boomer of the Night stream because I saw it on my feed. And I thought, why not? Offer a little support. So, keep working on it just like I keep working on mine. And we'll both get better. Zidea 80 says, in uh, response to this James Charles lawsuit thing, says her issue was she was doing the job of two people, and it asked that her prior position would be filled so she could focus on her new job. I also feel that she wanted one effing week off to recover so she'd be able to come back and do her job properly. Kind of says a lot about James if he's not one to give her a week off. Maybe it does. Maybe it does. It's not like she was asking for a whole month. Well, I don't know about that. What a shifty, uncompassionate person. He might very well be. But we're trying to get into the facts and we'll see how it develops. In response to the pushback on the Nicholas, so this guy was one of the Capitol rioters. This guy's name is Nicholas Alvera Gonzalez. And I got some pushback and I responded to a whole series of them. So Mortham says, how is yours not defamation and mine defamation? Well, I don't know. I'd have to see exactly what the context is. But it wouldn't be defamation if I was presenting an opinion, for example. Deface and defame are different words. I know. That's why I kept making fun of it. Deface can be used to refer to the idea of the face. Okay, yeah, except deface is not a thing in law in this context. That was my point of mentioning it a lot. Face is like public perception of character. There's a huge difference between describing someone's character when you are a direct witness and taking another party's words at face value as credible, which is why the person is saying you are defacing the person, but the FBI is not. So I'm defacing the person. I'm defacing the person because I'm taking another party's words at face value as credible. But the other party in this equation is the FBI. So I am taking the FBI's words at face value as credible. Well, yeah, kind of. Yes, because the FBI provided receipts. They provided images and quotes and all kinds of stuff that we talked about. So I'm taking the statements of the FBI at face value because they presented the evidence to me. And I'm looking at this evidence. I'm like, yep, that seems to confirm the FBI story to me. Looks like what the FBI is saying kind of tracks reality. So apparently the FBI didn't deface this person, but I did because I took the FBI's word for it, as informed by the videos and images and so forth and so on. And therefore I was defacing them or something. Not so sure about that one. Yeah, the FBI isn't always right. They're not always God. It sometimes knows they get it wrong too. The FBI has had some history in the past. The FBI is more than well aware of. But, when they provide the images and stuff and they provide the confessions and the videos and all the things, and we got him with his clown pants on, American flag pants, standing in the rotunda. And I know it's the rotunda because I've been there. And they say, yeah, he's in the rotunda. I'm like, yep, looks like it's me. So that would be kind of why we're taking the FBI's word for it. They have pictures. Ooh, Sin watches. Nice idea. Ooh, Sin watch. It does make a nice watch. Yellow Jacket. Good call. Yeah, they do make some nice watches. Jay Astor says, can a mod help me? I don't seem to have an Uncivil badge, although I've been a member since Saturday. That's on the YouTube. That's a YouTube thing, and the mods can't give it to you. So I double check your membership, make sure it's active, and otherwise wait for YouTube to decide to, acknowledge it, because it's a YouTube thing. So, there's nothing my mods can do here. Unfortunately. We had my mods without wrenches for a couple months. That was fun. We had stealth. That's how bad it was. We had stealth mods. We had stealth mods who didn't have wrenches. There was nothing I could do about it. Do you have access to the emoji? Do you have access to the channel emotes? Do you have access to our special emotes in your emojis? Do I have access to my own special emotes? I do. Yeah, so if you go down to emojis and click on the little icon, you should have little emojis that you can give. We got a little hat here. You can join that hat life. Very critical. Come on. Yeah, there you go. Improv says, this series has been a favorite of mine. Some of these people are so dumb. I really appreciate your adherence to rule of law and respect for the Capitol building. I'd also be on board for some of the more stupid and or interesting BLM Antifa idiots that got busted. Yeah, me too. I have no problem going after theirs. But that's more scattershot and less federal. True. Yeah, but I'd be happy. In response to the James Charles lawsuit, the comment about butt shaving was referring to an article that was recently written and contained more allegations about James Charles that was not put in the filings. I really don't care at all if James Charles shaves his butt or not. I can't even begin to tell you how much I don't care. A public defender cannot tell you to take a plea deal. Sure, they can. If it's in their best advice. I mean, in so much as they can't strict. Well, it depends what you mean by tell. They can't make you. They can't order you to, but they can certainly recommend it. They can certainly say it's in your best interest. What do you mean a public defender can't tell you to take it? Yes, they can. A public defender works for you, just like any other lawyer does. They're just paid differently. They're still your lawyer. If they feel that's in your best advice, if they feel their best advice is you should take the deal, they can recommend it. They can't make you take it, nor can your own private lawyer make you. Yeah. Okay, yeah, they can't make you. That's right. Your own lawyer can't make you. No one's lawyer can make them. The decisions for the client, the decisions that are solely the client's are the decision to plead guilty or not, the decision whether or not to take the stand. What else is for the client? The decision whether or not to appeal. I think there's one more. What's the fourth one? Plead guilty or not, testify or not, appeal or not. What's the fourth one? I forget. Matt, what's the fourth one? Your legal representative, the right to a lawyer? Yeah, I guess. You'd rather be a fool for a client than use a public defender. I would not recommend that. Lots of public defenders can be very good. I've seen lots of great public defenders. Jury trial or not. That sounds right. Yeah, jury trial or not. That sounds right. Yeah, but lots of public defenders can be really, really good. So, yeah. Can I just declare independence instead of go to trial? Can you declare that you don't want a lawyer? Sure. Does that mean you're not going to go to trial? No, unless you want to plead guilty. So, in response to the Matt Pat thing, that's an old video. That's really old video. In response to when Matt Pat said he was defrauded by Ally Bank, and I'm like, no, you weren't. That's a really old video. So DeFros apparently came upon this video and said these scammers are using Ally Banking as a front. They're legally acquiring closed loans on assets and calling the customers saying the monies were delivered to the wrong place. They either need a payment or a full payment to another location not set up through the true Ally Bank. I don't know what that means. I don't understand it, and I don't. And if they're closed loans, they don't need payments because they're closed. So I'm not sure what the scam is going on here, but no. Can you explain no contest? I'm in traffic court. Yes. So it's basically saying it's saying that you're not. It's saying you're guilty. It's equivalent to a guilty plea. It's a very small technical difference, and no contest is a very technical difference. It can't be used against you in civil court is the big difference. But A no contest plea is just saying, I'm not going to contest the facts. You have enough to find me guilty. So it's basically a guilty plea in all but name. It has all the same impact as a guilty plea. The only reason that it exists is that it can't be used against you in a civil case. So if someone were going to sue you, you can't use a no contest plea like you can a guilty plea. So, yeah. Is the fourth one settlement? I think it was jury trial. To respond to Melanie in chat, yeah, the UCMJ is going to have a field day with this guy. Article 94 of the Uniform Code of Military Justice. Any person subject to this chapter who, with intent to cause the overthrow or destruction of lawful civil authority, creates, in concert with any other person, revolt, violence, or disturbance against that authority is guilty of sedition. Yeah, that sounds bad. Yeah. Rioting, conspiracy, conduct unbecoming, prejudice against good order and discipline. Yeah, so he's going to jail forever. He's going to jail forever. Melanie's here. Yeah. We respond to everybody, or we try to. What does null pros mean? It just means the government's dropping the charges. Nolle prosse. Every lawyer says null pros because it's easier. It just means a dismissal of the charges. It literally means not prosecuted. It just literally means not prosecuted. So it's dropping the charges as null pros. So if the government says we want a null pros, it means they can come back with them later, technically. But they're dropping them for the moment. So yeah, it's like, well, these charges that exist, we're going to dismiss them. So it's called null prosing. It's technically nolle prosecule or some bullshit. And every lawyer I know just calls it null pros because we can't remember the longer phrase. The traffic court says that saying you're guilty is just not exactly what they say you are. Examples how fast you speed, that's what's confusing. It's very technically not saying you're guilty, it's just saying that they have enough to convict me, which is not quite the same thing. But for all practical purposes, it probably won't matter one way or another. That being said, if they will let you know pros, or apologize, if they'll let you do a no contest, and you want to go that way, then I'd pick no contest over guilty every time, because there's no reason to pick guilty over. There's basically no reason I can think of. There's no reason I can think of to take guilty over a not no contest. So yeah. How is Mississippi still unscathed? That's a really, really good question for the Capitol Riots. How is Mississippi unscathed? That is a good one. Rioters get what they deserve. Document your crimes, fair trials, and throw the book at them. If they wore masks, they wouldn't be facing 30 years in jail. It would have been a lot harder. What is this thread that's going on now? Some bullshit thread that I can't even be bothered to deal with. You took 4 years of Latin in high school, should become an attorney, so I flexed. I took 2 years of Latin in middle school, and the only thing I can remember is how to count in Roman numerals. So, you got that going on for me. Well, I think that's enough for tonight. That's enough hangout. We've been here an hour. That's about how long this typically goes. We had fun. I hope you had fun. I had fun as always. We'll be on tomorrow with Nate and Legal Bites. Alita will be on my channel tomorrow. Very exciting for our weekly hangout. I don't know what we'll talk about. I'll try to figure it out later, but it could be fun. If you're enjoying the stream, please remember to give it a thumbs up. If you're not already subscribed, please hit the subscribe button. And for 99 cents, you too can become a supporter of the channel. It helps us support it financially so this channel can grow. I hope all has been well. Until later, my friends, cheers and good night.